The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We are here at the time set for oral argument in file number 2025-0251, Chauncey Joseph Sandness versus Alea Moen Smith. Sitting today are Justices Jared Tufte, Justice John Jensen, Justice Douglas Barr, Justice Mark Fries, and I am Lisa Fair-McKevers. Arguing this morning is Elise Fisher, and I got a note. This is your client sitting with you, is that right? This is, all right, so that's Ms. Smith. And counsel for the appellee this morning is Brianna Delorme. So Ms. Fisher, when you're ready, you may proceed. And you have 10 minutes reserved for rebuttal, is my understanding. Thank you.
Good morning, Honorable Chief Justice and Justices of the Supreme Court. I'm Elise Fisher. I'm here for the appellant, Alea Smith. This case is a case of abhorrent process, unwarranted roadblocks on a great mother, and findings which are not supported by the weight of the evidence. First, the district court entered an ex parte order in a way which Rule 8.2 forbids, and that improper interim arrangement then shaped the final result in this case. Second, the final findings do not meaningfully address material evidence which was favorable to the appellant, despite the court's express assurance that the split hearing structure, which occurred in January and February of 2025, would not matter because it would rely on transcripts and notes. Third, the court's denial of the venue request on an incorrect view that there was no legal basis for the transfer, even though the facts had materially shifted to Morton County. In its findings of fact, in order to amend the judgment, which is at docket number 196 in this case, the district court awarded primary residential responsibility to the plaintiff and appellee in this matter, citing the impact of extended family based on the involvement of the plaintiff's mother, conceded the facts and circumstances for residential responsibility favored the appellant prior to the ex parte interim order, granted the appellee final decision-making authority on major issues without ordering any dispute resolution process, and in effect granting the appellee primary decision-making authority. The court found that both parents were fit, but concluded that the appellee's extended family support weighed in his favor. Your Honors, this case starts with process. The district court entered an ex parte order, which in substance changed the residential responsibility arrangement. Even after the order was revised, the practical effect of the order remained the same. The status quo was changed through an ex parte mechanism, which was improper under Rule 8.2, and that changed the status quo, which then became the platform for the final judgment. The interim order did more than just preserve the existing status quo at that time. It altered it.
Have we ever accepted that lock-in effect of an interim order as leading to error in the district court?
I'm not aware of any case law where the court has fully analyze the issue. When it comes up in Supreme Court arguments and briefs, the Supreme Court typically decides other issues are what reverse and remand the appeal. There are cases out there where the court just essentially declines to determine whether or not the issue of the interim order is what predicated the final judgment.
Counsel, it seems to me you're arguing that the court can never enter an interim order because whether it's 2 months or 9 months before the hearing, that's going to alter potentially who during that interim period had residential responsibility.
And Your Honor, that's not the issue here. The interim order that was entered in this case was an ex parte interim order. The parties had joint residential responsibility under an existing judgment and parenting plan.
Wasn't that order vacated and a new one put in place?
It was, Your Honor. So the ex parte interim order that was originally entered was objected to in the district court by myself.
So the district court has already corrected that error.
The district court, in exchange, entered a second amended interim order. The effect of that order was giving residential responsibility to the appellee in this matter. It so limited
to
my
my
client's
question.
parenting time.
That goes to my question, counsel. Isn't that always the case? We've had people argue, well, if I had residential responsibility for 6 months because of an interim order, and therefore I should be favored. But there's nothing that says the court unduly relied on anything that happened after this interim order was issued.
So in the interim order itself, the effect of it was that it changed custody from a joint residential responsibility arrangement essentially to primary residential with the appellee without using that language specifically. The language in the first amended interim order was that my client's parenting time would be supervised. And then after hearing the second amended interim order is what controlled. That interim order after hearing is not what's at issue. It's the original order, which changed essentially residential responsibility without using that language. And then the court relied on that order.
Isn't that semantics? It was the facts that the court relied on and placed in the order that changed residential responsibility, not the order itself.
The order that was eventually entered, the court did not give any information that my client was a danger to the children. There were no exigent circumstances to be entering an interim order, an ex parte interim order. The parties lived in different counties. It was, I believe, undisputed that a joint residential responsibility arrangement wouldn't have worked. They lived halfway across the state from each other. However, it is disputed that residential responsibility was placed with the wrong parent because residential responsibility had changed for more than 6 months. Going back to your question, Your Honor, the final judgment in this case did indicate that the facts favored the appellant prior to that ex parte change in residential responsibility that the court relied on. And that's really the crux of this whole case, Your Honor. Even though the interim order was temporary, it was reviewable now because it affected the merits of the judgment.
Could you identify or point out in your brief where you have identified the specific findings which are clearly erroneous? Because I'm not seeing too many citations to specific findings that you think are incorrect.
Yes, Your Honor.
It's hard for us to look at an order that's full of findings of fact when you don't identify the specific findings that you are
Yes, Your Honor.
objecting to.
I'm just pulling the judgment up. So there's multiple findings on throughout the best interest factors of the children living with the appellant from March or April of 2023 until March of 2024. Essentially, both children were living with the appellant from the younger child was living with the appellant from March of 2023 until March of 2024. In March of 2024, the older child also joined the appellant in the Bismarck-Mandan area and began living with her full-time. So she had both children from March of 2024 until the ex parte proceedings in August of 2024. That fact is in almost every single best interest factor that the court outlined. The The sufficiency and stability of the home, all of the findings under that factor. The home, school, and community records and the potential effect of any change. And under that factor, factor H, that is where the court specifically indicates that while this factor would have favored Ms. Smith at the end of the 23-24 school year, it is now neutral as the elder child is doing well at mini H this school year, and that was in the Grand Forks area. And so those are the facts heavily at issue with the change of residential responsibility that occurred with the ex parte interim order. Additionally, in the interim order, under Rule 8.2 with an ex parte order, unless the court specifically finds exceptional circumstances, no ex parte interim order may be entered. There must be a threat of imminent danger of any minor child or any party, or circumstances indicating that an ex parte order is necessary to protect the parties, the minor child, or the marital estate. In this case, there is no marital estate. The court made no such finding. There's no findings whatsoever that the children were endangered in the appellant's care, and offered no justification for the ex parte deprivation of custody or the restriction of her parenting time. In addition to the order in itself being contrary to the existing law, the contents of the order were contrary to existing law, as it delegated complete authority of parenting time to the appellee in this matter. It declared that he had the ultimate authority to decide when the appellant would get parenting time. The findings do not show a meaningful consideration of the appellant's evidence and minimize the important evidence of her stability and support system. When the case went to trial in this matter, the appellee was not ready to proceed. The appellant presented evidence as scheduled and continued the appellee's case. Counsel raised concern at the time of hearing that appellant's evidence later could create a recency problem. The court responded that primacy and recency would not matter because it does not usually rule from the bench. It keeps notes, reviews transcripts, and relies on post-trial submissions. This is all evident within the transcript. However, the product does not reflect that. The final findings do not meaningfully grapple with substantial evidence that the appellant presented in January. Some of her evidence is wholly ignored. Most importantly, she testified that the older child returned to her care at the end of March 2024 because he was struggling in Devil's Lake behaviorally and educationally. He had missed substantial school, was going to repeat kindergarten. She enrolled him in school in Theodore Jamerson in Bismarck-Mandan on April 1st. His behavior improved drastically. He did not miss one day of school while in her care. Yet the findings ultimately neutralize that evidence by looking at how things appeared after the interim shift when he was back in Devil's Lake. That's not a fair weighing of the pre-interim record. It's a reliance on a status quo created by an ex parte interim order that was illegally entered. She testified that she maintained stable housing, employment, and schooling arrangements in Bismarck, and that both children were thriving when they were in her care. She denied any conduct endangering the children and described ongoing interference with communication by the appellee during the pendency of the ex parte order. She was frequently trying to call the children, and there were issues with communication between her and the children. Additionally, within the findings, the court, I'll go specifically, under Factor B, there was a multitude of things that she testified to that were just totally ignored and not considered. There's findings that she couldn't pay her daycare bill and paid the bill for her. However, her own testimony was that she paid all daycare bills, that she had never asked for assistance on a daycare bill, and that the appellee only helped her on 2 daycare bills. Additionally, the vehicle, she did purchase her own vehicle. That fact was wholly ignored under that factor. The court seemingly didn't consider the 1.5 to 2 years she had both children. She provided daycare, she provided food, she provided a home. She lived in the same home for that entire time period. She never changed. She was never late on rent. She provided sufficient clothing, sufficient medical care. All of these things, none of them were disputed by the appellee. The child's developmental needs and the ability of each parent to meet those needs. The testimony indicated that the older child, improved significantly when he was in her care. He was going to repeat kindergarten prior to coming into her care. The sufficiency and stability of each parent's home and the impact of extended family, there was evidence under that factor that was wholly ignored. There was testimony that she had a cousin and a mother in the Bismarck-Mandan area. However, the court indicated that the cousin did not include an assisting child care, and there was no testimony that her mother or had provided care for the children. However, there was extensive testimony by Mr. Alberts that he's frequently in contact with her and the children and has a great relationship with them. The factor doesn't require that he provide child care. It is supposed to be a factor that evaluates the relationship of extended family with the children, and that was wholly ignored. The willingness and ability of each parent to facilitate and encourage a close relationship. And under factor F, the moral fitness of the parents, the court indicated that the appellant was manipulative in her relations with Mr. Sandness. That finding is not supported by the evidence. That finding is wholly unsupported. There's testimony by both parties that there was a breakdown in their relationship. There was no testimony provided that she had in any way manipulated the appellee for any purposes. In addition, the homeschooling community record, that factor itself, in looking at it prior to the interim order, the older child had missed 16 and a half days of school. That was just from the beginning of school through December. That's a significant amount of time. That's almost 3 weeks of school that the child missed.
And was there a reason in the record why the child missed that school?
He was having some behavioral problems, Your Honor. Most of them were unexcused. There may have been only four were unexcused. All of the rest of them were excused for one reason or another. One of the parents had called the child out.
So how does, if they're excused absences, how does that make a difference?
They were due to his behavior. He was being pulled out of school, Your Honor. And it was due to the appellee calling him out. The appellant did not have knowledge of many of the instances that he was missing school. He was also behind and almost needing to repeat kindergarten. Because of that, 3.5 weeks of school when you're 5 years old, that may have helped him to a point where he didn't need to repeat kindergarten. Additionally, as to the venue request, it was not legally baseless. The court's indication that the motion for change of venue was filed on September 16th of 2024. 2 days later, on September 18th, 2024, before the motion was even ripe to be considered by the district court, in a separate order, made the statement, it's at docket 143 in paragraph 6, that the motion was filed in bad faith in an effort not to have any interim order in place. That's not how procedurally a case works. The judge clearly already decided the motion prior to the motion even being ripe for consideration. Additionally, there is case law which indicates that venue can be changed post-judgment in a residential responsibility or divorce action when justice essentially so requires, when the facts are so removed.
Why does justice require it here?
In this case, the defendant and the children were not residents of Devils Lake or Ramsey County at the time that the filings were submitted. Essentially, custody had changed to Morton County. Defendant's residence had changed to Morton County. Here,
Where were most of the witnesses going to be for the trial?
in Morton County,
And were those people named and identified and the reasons for that in the motion and in the support of?
in the motion, I'm out of time, Your Honor.
You can use your rebuttal if you want, or you can answer the question when you come back.
I will answer the question when I come back, Your Honor. Thank you.
Ms. Delorme? When you're ready.
May it please the Court, Chief Justice McEvers and Justices of the Court, my name is Brianna Delorme and I represent the appellee Chauncey Sandness. Your Honors, the District Court conducted 2 days of testimony and issued detailed findings supported by the record. The District Court's amended judgment should be affirmed because the Court conducted a full evidentiary hearing, carefully evaluated the statutory best interest factors, and issued findings that are supported by the record. The appellant's arguments ultimately ask this Court to reweigh the evidence and substitute its judgment for that of the District Court's. But under this Court's clearly erroneous standard of review, the District Court's findings must be affirmed if they are supported by the evidence in the record, and here they are. This Court has repeatedly held that the District Court's decisions regarding residential responsibility is a finding of fact subject to the clearly erroneous standard of review. A finding is clearly erroneous only when it is induced by an erroneous view of the law, when no evidence supports it, or when the Court is left with a definite and firm conviction that a mistake has been made. And because the District Court's observes the witnesses firsthand, its credibility determinations are entitled to significant deference. This matter was tried over 2 evidentiary hearings before the District Court, the first occurring on January 3rd, 2025, and the hearing continued on February 11th, 2025. During those hearings, the Court heard testimony from both parents and other witnesses and admitted exhibits relating to the children's schooling, attendance records, and living arrangements. Following the hearings, the District Court issued detailed findings of fact and later entered an amended judgment awarding primary residential responsibility to Mr. Sandness. One of the central issues before the District Court was the children's stability and educational well-being. The evidence demonstrated that Mr. Sandness had taken an active role in addressing the child's educational needs. For example, Mr. Sandness testified that he regularly communicated with the child's teachers and participated in meetings with school staff to support the child's educational progress. This also went to the District Court's finding that Mr. Sandness had significant extended family support, given that his mother and grandmother spent a great deal of time involved in his education through after school, working with the older child while he was in kindergarten on reading skills and whatnot. In addition to that, his mother provided transportation to daycare and pick up from daycare as that occurred around 3 or 3:30 in the afternoon, and he was still working at Butler Machinery at the time. The Court also weighed Mr. Sandness's financial stability and gave that significant weight in its decision. In short, the district court conducted a full evidentiary hearing, heard testimony from both parties and other witnesses, evaluated the credibility, and carefully applied the statutory best interest factors. Because the district court's findings are supported by the record, they are not clearly erroneous. For those reasons, the amended judgment awarding primary residential responsibility to Mr. Sandness should be affirmed. I would also note, opposing counsel mentioned that one of the best interest factors that the district court evaluated specifically stated that that factor would have favored Ms. Smith at the end of 2023 to 2024 school year. It is now a neutral factor as the elder child is doing well at mini age this school year. That's only one factor, and it's very clear that 3 factors weigh in Mr. Sandness's favor, and that is what the district court determined when it evaluated all of them.
It appears the district court, in summarizing the weight of the factors, put a great deal of weight on the extended family of your client. Is that supported by the record?
Yes, it is, Your Honor. His mother did testify, and that is referenced in the transcripts on pages 154 through 156. And I believe that's also, or that's where Mr. Sandness is talking about his communications with the teachers and the educational progress of the older child, given his greater needs due to behaviors and his, he was slower than most children to learning to read, and so that was a significant reason as to why he was held back in the kindergarten year.
In regard to the district court's decision on the final decision-making authority, is there any requirement in our case law that there be mediation instead of having one parent make the final decision?
I guess I am not sure.
It looks like the district court gave each parent decision-making authority, but if they can't agree, your client gets the final word. And that's my question. Is that something that a court can just do in their discretion, or is there anything to keep them from applying that discretion?
I believe it can be applied, and my understanding of the court's reasoning as to why it did that was because there was a significant breakdown in communication between the parties leading up to this situation, and it was very clear through the testimony of both parties that they were not going to be able to communicate at all instances. And so given the nature of those circumstances, if they were unable to come to an agreement between the two of them, somebody ultimately had to be able to make a decision, especially if there was a timeline on that where they couldn't get into, say, mediation or something like that.
Ms. Delorme, Ms. Fisher noted that the court said that her client, Ms. Smith, was manipulative, and then asserted there was absolutely no facts to support that conclusion. Can you point to anything in the record that would support that conclusion?
So there was testimony regarding the sexual relationship between the parties, and that could be interpreted as manipulative because it also was in relation to him paying for different things for her, like a vehicle and whatnot.
But the district court correspondingly found that your client was immature in his response to some of that type of relationship as well, so they were kind of offset, correct?
Yes. That's my understanding of his reasoning. If the court has no other questions, I will cede the rest of my time.
All right, thank you, Ms. Delorme.
Thank you.
Ms. Fisher, you have 10 minutes for rebuttal.
Your Honor, Chief Justice, to answer your question, you had asked the question, would the witnesses have been mentioned in that motion for change of venue? Within the appellant's brief, there is a direct quote which indicates what was argued within the brief and with specificity, what the argument was of why venue should be changed. And in a few sentences, it was stated, in addition, the appellant and her support system live in Mandan. The children resided in Mandan as well up until the appellee was granted the ex parte interim order. The appellant, the children, and their entire support system lived in Mandan at the time of that motion for change of venue, making Morton County the proper venue to change residential responsibility. Additionally, the argument is that, the district court made the statement that it did not find any basis in law for the motion. There was a basis in law for the motion. It was an arguable motion to be made to the court. And additionally, the statement by the court prior to the motion being ripe that it was an attempt by the appellant to essentially have no interim order in place. Procedurally, that indicates that the district court did not understand process, as a motion for change of venue does not vacate all orders within a case. The orders would follow to the new county of venue. To respond to some of the arguments made by the appellee, there was an indication, significant extended family support by the appellee, that he had extended family and that support system was significant, and that weight was placed on that for the appellee. However, under that factor, factor D, there's no requirement within that factor that the extended family or the support system of a party live within the same community as that party. You can have a close extended family and live in separate communities. The appellant did have...
On your motion for change of venue, I see what you argued in your brief, but the fact that you have a support system in a county, how does that affect the hearing portion of it?
If
they're not going to testify, if they aren't identified as
They would
witnesses,
testify, Your Honor, and many of the witnesses that were present at trial.
That was my question, though. Were the witnesses and what they were going to testify to and their necessity identified in the motion and the supporting documents? Because what you've quoted here isn't, that
What
isn't
was
what it says.
identified, Your Honor, was the support system. It would have been inferred from the argument that the support system would have been there to support the appellant and testify for her. They weren't specifically named, no, Your Honor. Under Factor D, there's no requirement that the extended family or support system of a party reside in the same community. While community is one of the things that the court considers under that factor, there is a separate factor on the homeschool and community records of the child. The impact of extended family itself, you can have a close-knit family and not reside in the same area. There was substantial testimony by Ms. Smith's support system that they are very close with her and they're very close with the minor children. Every single one of her witnesses testified to that. They testified to how often they see the minor children, their relationships with the minor children, and their relationships with Ms. Smith. So the fact that that consideration was wholly ignored under the extended family factor. Additionally, the argument was made that three other factors would have weighed in the appellee's favor. And that was in relation to the best interest factor would have, the one that would have favored the appellant prior to that interim order. there were 3 others at the time that, or in the final judgment, that would have favored the appellee. However, in the appeal, we are making the argument that those findings are also either insufficient because they did not address the evidence put forth by Ms. Smith. Chief Justice, you had made the question, is there any requirement that mediation must be ordered as a tiebreaker before a party can have a third tiebreaker method? Your Honor, I'm not aware of any case law that indicates that. However, there is case law that indicates that there must be sufficient findings which back any reason that a district court makes to give one party, primary residential responsibility or primary decision-making authority. And in this case, that didn't happen here. While the parties did have some difficulties with co-parenting, it was clear prior to the August 2024 filings that these parties are capable of co-parenting. They are capable of making decisions together for their children. And the testimony at the time of trial, I do think supports that even though they may have issues with each other, they are still able to make decisions jointly for their children.
If that's the case, and your client has decision-making authority as well, unless they don't agree, they should be able to agree, then how is the court's decision to give one party or the other, whoever that might be, how is that an error?
In effect, it gives one party primary decision-making authority. In cases where this happens, when there's no third-party tiebreaker, one party could make the decision, tell the other party that they made that decision, and in this case, the appellant can do nothing about it. In addition, as to the manipulative statement, there was no sexual relationship between the parties. Within the testimony of both parties, Ms. Smith had indicated that Mr. Sandness had frequently made inappropriate sexual advances towards her. Her testimony indicated she never did anything to request that from him. She never reciprocated that behavior from him. She was not manipulative of Mr. Sandness. That's not clear in the findings. Additionally, the findings make this broad statement, and we're left to guess of what the court meant in those findings. Facially, that makes the findings insufficient. If we are left to guess, the findings are insufficient. And so our request would be that this court reverse and remand for further findings and for an additional trial, Your Honor. And we would request that the order denying the motion for change of venue also be remanded for reconsideration. Thank you.
Thank you for your argument this morning, Ms. Fisher, and yours as well, Ms. Delorme. This matter will be taken under advisement, as all cases are, and we will be adjourned until tomorrow afternoon at 1:30 p.m.